Welcome, everyone, to the intersection of speech and religion in the First Amendment. To send a question to the speaker, type in the box below the Participation tab. Materials for this course can be downloaded under the Supplements tab. The link to the survey can be found underneath your viewer window. It's my great pleasure now to introduce our presenter for the next hour, Clifford Rieders. Cliff, the floor is all yours.
Thank you very much. So this is Cliff Rieders, and we're talking about a subject today which engenders great discussion and debate. And of course, it's impossible, probably impossible, to really go over every case that might be relevant. For example, one of the cases that kind of intersects with the intersection here is a Citizens United, which was the case that said, well, speech encompasses many forms, including the spending of money. So there were lots of cases we left out, and we also looked into some arcane and interesting, even older state cases to try to bring to you what the scope of these issues are. And then we are as current as looking at this as a restatement third on defamation. So we'll begin with the beginning, and here we go. The reach of the First Amendment is really the first part of this. I might also mention to you that there are a lot of materials here, and just what you want to look at, whether you want to go through all of them, it's up to you if you have the time afterwards. I have no intention of going through every possible case because there is so much material in this field, but maybe it's a research tool for you at some later point in time. Okay, gotta make sure we go in the right direction. So the reach to the First Amendment is a continuing controversy. It's been a controversy almost since the founding of this republic, but certainly since the industrial age. I was reading an interesting dissenting opinion by Oliver Wendell Holmes on the question as to whether the Alien and Sedition Acts were constitutional during the First World War. And I remember my father telling an amusing story about his grandfather who spoke German in the house. They lived in New York City on Broadway. And my father was very young in World War I, but he was told to watch out for German spies. So when he heard his grandfather speaking German in the house, he told the cop on the street corner, which they had in those days, that he thought his grandfather was a German spy. So the old man, as they called Morris Rieders, was questioned as to his background and so forth. And according to my father, it's the only time he was ever spanked. So this has been a controversy for a long time, and the reach of the First Amendment continues as a controversy. Religious rights obviously are guaranteed, but so is a freedom to live without religious restrictions. So it cuts both ways, and we see different courts and different lawyers either assert the protections of the First Amendment or say, no, the First Amendment protects their religious behavior. So it can cut both ways, obviously. Religious discrimination is not necessarily protected by defamation laws, but there's some interesting case law on that. We'll take a look at some unique cases that may or may not still be good law, but they're on the books as to whether religious discrimination in certain respects is protected speech or whether it's a form of discrimination itself. So we'll start with New York Times versus Sullivan. Like I said earlier, we could start with earlier cases, but we'll start with New York Times versus Sullivan because it's one of the most cited cases in history. The rule of law applied by the Alabama courts said the Supreme Court was constitutionally deficient for failing to provide the petitioner the safeguards of freedom of speech and the press. The constitutional guarantee required a rule that prohibited a public official from recovering damages for defamatory falsehood relating to the public official's conduct unless the official proved that the statement was made with actual malice. Actual malice is that the statement was false or made with reckless disregard of whether it was false or not false. And I've had many phone calls over the years from public office holders, past president of the trial lawyers and other organizations, other bar-related organizations. So you get to know public officials. And some of the things that are said, not only by public officials, but about them as well, is pretty gross sometimes. We all know that just from the public discourse that we see on TV or in the press or whatever. And I've certainly been confronted with situations by some public officials where the question of malice seemed to be pretty clear question, that these things could not have been said without malicious intent. And yet, most public officials do not want to get into the situation where they have to prove actual malice. They know that's very difficult to do. So a lot of those cases really go by the wayside or are not brought because of that difficulty. Showing actual malice is a very major hurdle for those people who try these cases. And I can tell you that I almost always turn them down because it's difficult to show malicious intent. The another interesting case that would sort of again give us some idea about the parameters is the infamous case of Hustler Magazine versus Falwell, Jerry Falwell, the 1987 case. This was an action for libel, slander, intentional infliction of emotional distress due to publication of a caricature in an ad parody. The court said the damages were inconsistent with the First Amendment. Public figures required to show that statements published in advertising parody were made with actual malice or reckless disregard of the truth. So even in that context, which is not necessarily a discussion or debate about the virtues or lack thereof of Jerry Falwell, the court is still going to require actual malice, and they said the award of damages were inconsistent with the First Amendment. So pretty nasty stuff can be said about public figures, and whether it's actual malice or not, well, it's generally actual malice will still have to be proven. United States versus Eichmann was a 1990 case. As you can see, we're kind of moving up. And all these cases, they sort of morph. We talk about actual malice. Now we're talking about what makes behavior rather than speech, for example, or when is behavior symbolic speech. Symbolic speech is a relatively new concept. This was a flag burning case in violation of the Flag Protection Act of 1989, which you recall was passed specifically because of upset by some folks in the legislature, Congress, that flag burning was really a form of desecration in their mind. And the court said the government's interest in preserving the flag's function as an incident of sovereignty could not justify the act's infringement on the constitutional right of free speech by suppressing expression out of a concern for its likely communicative impact. So even though we're going to talk about cases in this field in a few moments, but even though we're talking here about action, not speech, we now see that speech does encompass action. Like I said in the very beginning, Citizens United, the action is writing a check, I suppose, or using the check to enhance one's views of what the policy or politics should be. And the court here said, and they have a lengthy discussion about it, it's an interesting read, that conduct could be speech. Not always, however, as we'll see in a few moments. And figuring out what that dividing line is has a lot to do with the politics of the court. But then again, so does every case. And I hate to blame decisions, as we all do, on, well, that's a composition of the court. This court will do something that some court 10 years ago or 20 years wouldn't have done. Well, that's true, but the same is true if you look at courts of 50 years ago or 100 years ago. The court is a changing, evolving institution, and it's a totally political institution. I wound up giving a seminar with a lawyer from another country not too long ago, in another country, and it was in Israel. And the question there at the time, before October 7th, was a debate over how judges to their Supreme Court should be appointed. And people seem to really be surprised or shocked, not just lawyers in that country, but American lawyers who listened in. And I think it was another one of these West Celeste seminars when I said, judicial appointments in the federal system in the United States are all political. I mean, whether you agree with it or don't agree with that, or like that or don't like that, that's the truth. And anybody listening to this who's been involved with appointment of federal judges or sat on committees that have recommended federal judges or dealt with U.S. senators on the subject know that the process is a political process. And it's frequently done by the president and Congress. People have said it to get votes. They want a particular law passed. They want the assistance of the senator. One way to get it is to give him or her the patronage that they want. So we have a very political system. Sometimes it works very well. We get some great judges, right? Sometimes it works terribly. But many states, like Pennsylvania, for example, which has an elective system, the elective system has its critics. And there are people who say the elective system is another form of politics, even a worse form of politics. So then there are those who believe there's such a thing as merit selection. And some of the critics of merit selection say, well, it's just another form of politics. People sit around smoke-filled rooms and they pick who should run for election, no matter how those commissions are set up. They're basically political functionaries. So I don't know which side of that debate you come down on. I'm not sure there's an answer or that I know the answer, but we're getting a little bit of feel of symbolic speech. All right. Another very important case is Rad versus St. Paul. It was the 1992 case. And it's an important case because you will see that it didn't take very long for, if you're going to look at Virginia versus Black in 2003, that went the opposite way. So how many years was that? Not that long, really, in the life of the court. Petitioner was charged with violating a St. Paul's bias-motivated crime ordinance for burning a cross in the yard of an African-American family. The ordinance prohibited display of a symbol which a person knows or has reason to know arouses anger, alarm, or resentment on the basis of race, color, creed, religion, or gender. So you would think that was a fairly clear and obvious statute, right? Well worded. Well, the court said even if the expression reached by the ordinance was prescribed under the fighting words doctrine, the ordinance was facially unconstitutional. Even if it was prescribed as fighting words, not permitted under that old, somewhat antique doctrine now, the ordinance was still, for other reasons, was facially unconstitutional. And why? Because it prohibited otherwise permitted speech solely on the basis of the subject of the speech addressed. Now, bear in mind, this was the burning of a cross. This wasn't a speech about crosses or African Americans. While the statute served a compelling interest, it did serve a compelling interest, okay, there were content-neutral alternatives available. The court reversed and struck down the bias-motivated crime ordinance as facially unconstitutional. Bear in mind, that was 1992. Could that ever be decided today? Well, maybe yes, maybe no. Maybe it depends on who it is who's being discriminated against, even. But we'll do this chronologically. So we'll talk about the Virginia versus Black in a few minutes. The other case that addresses these same issues, it was Madison versus Women's Health, 1994 U.S. Supreme Court case. Here, anti-abortion protesters challenged the constitutionality of an injunction entered by a Florida state court, which prohibited them from demonstrating in certain places and certain ways outside a health clinic that performed abortions. Now here, the court, pardon me, I know this is a terrible analogy, the court split the baby. Okay, I'm sorry. I shouldn't have said that. The court upheld noise restrictions and buffer zone around clinic entrances and driveway because they did not burden speech more than necessary to eliminate unlawful conduct. So they were looking at the traffic flow. They were looking at kind of the public need to be able to use the streets, the sidewalks, that type of thing. The court struck down as unconstitutional the buffer zone, however, as applied to private property to the north and west of the clinic. They had created a buffer zone. The images what they call the images observable provision, the no approach zone around the clinic, and the larger buffer zone around the residences. So they, to the extent that people could protest, but not be in the way, so to speak, of those using the streets and the sidewalks, that was a different analysis. But the court said the provisions went more broadly than necessary to accomplish the permissible goal of the injunction, which was to permit ingress and egress to the clinic. These cases, by the way, become important because we're going to talk in a few minutes about current protests that are going on in the United States now, where you have this whole panoply of activity. You have people protesting, carrying flags, using bullhorns, but you also have people blocking, threatening others, effectively locking students in their classroom. So these cases, I suspect, as the years progress, will percolate up. And what the court will struggle with on these pro-Hamas protests are to what extent are they are they speech, and to what extent are they not speech, but rather action, which prohibits people from carrying on their everyday daily activities, like driving their cars over a bridge, like getting into or out of a classroom, all these kind of things. And certainly those actions are going to be found to be subject to regulation. People are not going to, they're not going to, the court's not going to say that the First Amendment permits people to block the Brooklyn Bridge because they're protesting a political matter that they feel strongly about. But if they want to walk around with flags or with bullhorns and you're not keeping people up in the middle of the night, they're certainly going to be permitted to do that. So then we get to Schenck versus Pro-Choice Network, 1994. You can see these cases, they kind of fall into certain areas, right? You have the era of where you're dealing about discrimination against African Americans. You have then of course you have a whole bunch of cases that came out as a result of the abortion controversy. So here in Schenck, the court upheld an injunction imposing fixed buffer zone. They upheld the injunction imposing fixed buffer zones, prohibiting demonstrations within so many feet of doorways, parking lot entrances, driveways. So that's very consistent with what I've been saying in the prior case law, where these are not traditional public forums. The court invalidated a provision, however, creating a floating buffer zone, which banned demonstrations within 15 feet of any person or vehicle seeking access to or leaving the clinic because the restriction on free speech was more than necessary to serve the relevant government interest. So you can't, again, it's a balance. The court is not going to permit the interference with everyday activities of driving and walking, but they are going to permit demonstrators to get, in the face of those that they want to reach with respect to their message to some degree. The court upheld the cease and desist provision that required counselors within fixed zones to retreat 15 feet from any person who indicated desire not to be counseled, because the restriction was not a content-based speech restriction contrary to the First Amendment. What they were doing, again, this is an interesting mixture, right? They were requiring that certain action not take place, but that action related to speech. So the 15 feet retreat is a physical manifestation of communication, but communication with something a bit different. So again, you can see these cases are relatively consistent when we're talking about the abortion issue. Now, Virginia versus Black, I promise you we talk about that. It just goes to show you how the pendulum swings in Virginia versus Black. We're now in 2003. There was a state law that prohibited cross burnings with intent to intimidate. A little different than the wording of the other statute. The prohibition of cross burning with an intent to intimidate was not unconstitutional, since it banned conduct rather than expression. The prohibition, I want to read that again, because this is really the key of what we're talking about here. The prohibition of cross burnings with intent to intimidate was not unconstitutional because it banned conduct rather than expression. Now, earlier we talked about conduct that is based upon the right to express oneself, flag burnings, for example, writing a check to a political party. So again, we're struggling with the question as to what is a difference in conduct and expression, and when is conduct expression and when is it not. And it's very factually explicit, and it's also has a lot to do with the political tide at the time, which I said earlier really shouldn't be that much of a consideration because the political tides are always turning, right? Cross burning could constitute expression. It could constitute expression, they say, and it was prescribed unless it was done with an intent to intimidate. And I don't know how it could not be done with it. I don't know how it could ever not be done with intent to intimidate. And targeting cross burning was reasonable because cross burning was historically a particular virulent form of intimidation. So the court felt it was necessary to say that the court felt it was necessary to say that speech can be conduct, that conduct can be speech, and they relied on this intent to intimidate. But in the case of cross burnings, is going to be an intent to intimidate. Why else would you do it? Now, you've had people try to test this doctrine by burning across not anybody's property in particular, but in order to object to matters that were occurring in the community or even within the church itself. There have been all cross-burning for all kinds of reasons, some more understandable than others. But the plurality of the Supreme Court of Virginia versus Black asserted that the statutory provision of any cross-burning with prima facie evidence of intent to discriminate by itself could support a conviction without further evidence of intent to be an unconstitutional restraint on speech. So basically any cross-burning is prima facie evidence of intent to discriminate and could support a conviction, criminal conviction here. So that really have to make us question other activities. You start to think about other activities which by themselves are the evidence to intimidate. So for example, there have been synagogues across the United States where people have shown up with blood on their hands and pictures of bloody babies, which they claim are injured or hurt by a war they don't agree with or they disapprove of, and of course their behavior is intending to intimidate. So where these cases go, and when we are willing to presume an intent to discriminate, is uncharted territory, and I think that will continue to develop and evolve and fill in as the United States continues to deal with a very heterogeneous and diverse community, where people now take the position that they need to make their communication clear by being at each other's throat. And as that speech becomes more aggressive and is acted out in physical circumstances, the courts will have to go back to these cases to try to determine when is this behavior, call it behavior for a minute, not speech, but conduct, which ipso facto, prima facie, represents an intent to intimidate. Stay tuned. United States versus Williams was a criminal statute outlawing offers to provide or request to obtain child pornography, and the court said that they are categorically excluded from the First Amendment. So the court is kind of an incremental step up. Some would say more than an increment. And they say that at some point we cross the line when we talk about speech, so that requests that are highly offensive, like attempting to promote child pornography, it's not even going to be within the First Amendment ambit. At one time, advertising was considered not within the First Amendment. At one time, prior to Citizens United, the writing of checks of political was not considered political expression protected by the First Amendment. There are all kinds of things that were not within the First Amendment, but now we're saying, the courts are saying, this is enough of a national problem. There was enough publicity on this, and no federal judge sitting around could say that this was speech, let alone legitimate speech. Okay. Make sure I'm going the right way here. Brown decision, first, which is a 2011 case. Also a very interesting case. They're all interesting cases that they wouldn't get to the U.S. Supreme Court, right? State of California passed a law prohibiting the sale and rental of violent video games to minors. This is probably a bigger issue today than this was in 2011. The statute violated the First Amendment, said the court. The video games were protected means of expression of the First Amendment. Now, again, that is a considerable expansion of the First Amendment because it's not political speech. And once upon a time, the First Amendment was really supposed to be concerned only with political speech. Now we say the First Amendment protections found the law both under-inclusive and over-inclusive. Why? It was under-inclusive because it did not provide minors from having, it did not prevent, I think that's supposed to be, minors from having access to information about violence in other forms, only in video games. So I wonder if this would have been different if they would have banned the dissemination of anything that was considered violent to minors. I doubt that would have made a difference. It was over-inclusive because it abridged the First Amendment right of young people whose parents and others thought the violent video games were a harmless pastime. I said earlier that I'm not sure this decision would go this way today, because I'm not sure anybody considers them to be a harmless pastime anymore. There's been enough scrutiny of these games and enough psychological and neuropsychological study We now have, we now have some knowledge and some history about the effect of these games. So I'm just, who knows if it would, a well-drafted statute might actually make it this time, but it did not survive the strict scrutiny analysis. Snyder versus Phelps. I found this a very disturbing decision. They're all, they're all somewhat disturbing because they're compromises, right? Every decision of the Supreme Court is that kind of compromise. So here, the petitioner, father of a Marine who was killed in the line of duty, won a jury verdict from defendant protesters who picketed for 30 minutes before the funeral began on public land 1,000 feet from the church where the funeral was held. The court found, and these were well-behaved protesters. I think that had a lot to do with this decision. The protesters had a right to be where they were. They had a legal right to be there. They were on public land. The local authorities had been alerted to the funeral protest, and the protesters complied with police guidance on picketing. They stood behind the cordon. They were cordoned off. Picketing was conducted under police supervision, 1,000 feet from the church, out of sight to those who were at the church. I think that was a very key component of this. The protest was not unruly, no shouting, profanity, or violence. So here, the Supreme Court was almost sitting as a trial court. It was looking at the facts, the very specific facts, not whether the behavior represented speech versus illegal action. And the court said that, well, it might be odious and disgusting to people. Nevertheless, they complied with the requirement that their behavior remain speech and not become something else. That's really how this decision went and why it went the way that it did. Countermeasure versus Colorado. So now we're up to 2023. Now, threats, again, you got a different court, you have an evolving standard, you got this whole history of cases behind you. True threats of violence, bear in mind that word true, are outside the bounds of the First Amendment protection. First Amendment still requires proof that defendant had some subjective understanding of the threatening nature of the statements. Now we enter the world of subjective versus objective, which we talked about a little bit earlier in connection with the cross-burning cases, where the court said, well, we're going to kind of make a prima facie decision on this. Here, a mental state of recklessness is sufficient because it offers enough breathing space for protected speech. So recklessness, now we want to get into the tort standards, recklessness in many states suggests behavior in which a person knowingly rejects an appropriate standard of care. So when we talk about recklessness, we're talking about something above and beyond negligence. We're talking about something that suggests knowledge on the part of the individuals who's thus behaving. In Canada versus Colorado, the state must show that the defendant consciously disregarded a substantial risk that communication would be viewed as threatening violence. So that's what I said to you a little bit earlier, conscious disregard, a knowing disregard in some states. Petitioner's prosecution, in accordance with an objective standard, was a violation of the First Amendment. It was not what everybody in the jury would have thought. It's what this person thought. Because the state had to show only that a reasonable person would understand the statement as threats, reasonable person being those jurors. And they did not have to show any awareness on his part that the statements could be understood that way. So the court, remind you of New York Times versus Sullivan in these cases. The court is taking the tort law and importing the tort law into the constitutional framework by saying, it's not enough that somebody just be negligent. It's not enough that 12 reasonable jurors think that these statements were threats. What's required is that the individual have a kind of mens rea, kind of a tort-related mens rea. That is, that the actor be reckless, as that's defined in some but not all states. Reckless meaning that the individual had knowledge, a conscious kind of knowledge, which they then decide to disregard. They make a conscious decision to disregard. So we've imported a tort concept into the First Amendment in terms of the person's behavior, in terms really of the person's speech, because the court was concerned that if you left it up to individual juries or judges as to what the standard of care should be, and in this case, as to what the standard of behavior should be, that it might be too easy a standard to meet. And I think that in so doing, the court rejected another one of those great admonitions by Cardozo and Holmes, that the language of the law is experience, and that experience is the group wisdom of the jury, of those who look at behaviors as to whether they are reasonable. The court did not view it that way in Counter versus Colorado. Again, you could read it and you might find it to be factually specific in that respect. But anyway, I've got to, for those of you in New York State, I'm one of those New York State people too, as well as Pennsylvania. I need to read you your program code. Somebody told me I need to do this twice. So let me read it to you. Your program code is CR 3463-40924. CR 3463-40924. So I guess you need to know that, and I read it to you. In order to comply with New York State regulations, lawyers looking for CLE credit in New York will need to be able to provide this code. Code is not intended for the audience, except to the extent that you need it in your reporting. I read it twice, and I hope that makes everybody happy. I think I've done my due diligence there. So I wanted to fast forward. So think about all these cases in the context of what's happening today. This is today's world, but next week or next month or next year, it could be somebody else or some other group. So try to look at this, take this out of the political context or your views as to what's going on in the Middle East. But and just look at it from a factually applicable situation, because you've got a whole series of cases that address when behaviors become speech, when behaviors are not speech, when behaviors are sufficiently egregious so that they go beyond those protections afforded by the First Amendment, where they block streets or roads or access to buildings. So we have a fair amount of case law dealing with whether riots, protests, some consisting of mere words, others not, against Jewish people, Jewish interests, institutions, on public highways or airports, are protected by the First Amendment. So it clearly depends upon the nature of the action, who it interferes with, and how, the intent of the protesters. We talked a lot about intent, their subjective purpose, and the impact on others. Clearly, many acts and statements by pro-Hamas interests have been specifically, and they say so, specifically to intimidate, frighten, and prevent the speech of others. They've gone on college campuses, and some of that speech could be prosecuted criminally. I spoke myself at Georgetown on January 31st about the legal implications of all of this. And the school made it clear that if there were to be any protests, they had to be outside the building, and that any students who disrupted other people or prevented other people from speaking, or themselves violating the First Amendment principles of that school, and would be expelled. So there were no problems. And I would have been happy to relinquish the floor and let anybody speak about whatever they wanted to speak about. But the protesters' veto, as it's called by some justices and judges, is something that we will, I think, always be dealing with, whether it was in the context of labor unrest or whether it was in the context of objecting or supporting, for that matter, war, World War I, World War II. You're always going to have this question about when a protest, when a behavior goes beyond words and affects interests that are not legitimate targets of speech. So give that some thought. The First Amendment and religious freedom. So we'll deal with that a little bit here in the second half. Talk about some of these cases. Some of them are interesting, others a little quirkish, but it kind of give you a flavor of what this is all about. We've all heard debate as to whether the First Amendment protects citizens from religion or supports a free exercise of religion. And I have worked with or counseled different organizations on both sides of that debate. It's an interesting one. Of course, one of the major cases on that is a recent 2023 case of 303 Creative. By the way, the answer to the question I pose is really both, if we're going to be honest about it. That was an interesting cake. I don't think that was a cake that was actually made in that case. But the person who helped me with this PowerPoint managed to come up with that multi-layered cake. A cake maker may refuse to make a cake for a gay couple based upon religious scruples. But a gay couple cannot be excluded from a public accommodation. And that's, by the way, that's my addition. So you do have that countervailing consideration that to the extent that a store or business is a public accommodation, you can't necessarily keep people out because you disapprove of them or you don't like what they're all about, like when African Americans were, kept out of the diner in the South. And thank goodness for Title VII and for other legislation passed in 1964 and thereafter. That was behavior that went by the wayside. So we don't generally say just because A doesn't like B, they can do whatever they want to do. But whether they're required to do something within their profession, within their work, is another story. So of course you can imagine a scenario of a whole bunch of issues about lawyers, right? Lawyer says I refuse to work for gay people, or a gay lawyer says I refuse to work for straight people. Or, I mean, you can imagine what a slippery slope this can be. But I think this case will probably be somewhat held to its facts. But I mean, only time will tell. The question has been raised as to whether bigotry can amount to defamation or whether it enjoys First Amendment protection. That's a very interesting question, which I have answered for some individuals and some organizations. And I've always taken the position that it's very difficult to shall we say, punish bigotry using the laws of defamation for a whole host of reasons. And most of those reasons are that the courts are just not comfortable with punishing or letting juries punish somebody's opinion, even if it's an opinion that is odious and disgusting. But this is an argument that is going to have new life in it. You're going to be seeing more about this question as our country becomes more diverse and our judiciary, frankly, becomes more diverse. So bigotry is defined as intolerance towards those who hold different opinions from oneself. So that's pretty simple. That's one definition. There's tons of them, as you can imagine. Let's start with group defamation, because that's where we see this come up the most. So we have an interesting 1942 Second Circuit case. There's an old adage among those who teach in law school, which I do occasionally, that no case more than 25 years old is worth citing. I don't buy that, because even if the composition of the courts and society has changed, it still gives us an historical paper trail, so to speak. So this case, some of you might remember the name or be familiar with the name of Father Conklin. Father Conklin was a known anti-Semite. He had a program in I think in Michigan, and he would rant and rave about Jewish conspiracies, among other things. Well, here a non-Jewish congressman, and she spoke with Father Conklin, opposed the appointment of a judge of Jewish heritage who was not born in the U.S. The judge left the decision about whether defamation occurred to the jury, holding that federal cases in New York for defamation must allege special damages, which is a term you see in a lot of states. We don't really have that in Pennsylvania. New York does abide by that rule in a variety of cases. In order to have a claim of defamation go forward, the case never went to trial because there was a dismissal on summary judgment. The evidence just was not, court found, was not sufficient, but theoretically possible. Milkovich versus Learned Journal was a 1990 Supreme Court case. Does the First Amendment require a separate opinion privilege, limiting the reach of state defamation laws? Many states, at least states where I practice, do have an opinion privilege. And if something is an opinion, it can't be defamatory. Again, that's something I've been consulted upon many, many times by people whose opinions are disgusting to others, or who want to be able to express their opinions in an unpleasant way. So it's when I was researching this, I was surprised to find it was more debate on this than I thought there was. I figured opinion is always protected, but expression of fact versus opinion about another. The newspaper believed, in this case, that went up, that a wrestling coach had caused a brawl by publicly challenging the decision of the referees. The holding was that the First Amendment does not require a separate opinion privilege, limiting the application of state defamation laws. I mean, if they have it, they have it, but they don't have to. While the amendment does limit such application, New York Times versus Sullivan, the breathing space that freedom of expression required to survive is adequately secured by existing constitutional doctrine. And the case was dismissed. So that was a little bit of a surprise. But as we've discussed earlier, what some of those doctrines are, including the necessity to show malice for a public figure. And then there's a host of cases that make it fairly easy for somebody to be called a public figure. Gibson versus Oberlin College, very interesting case. I have a friend who is somehow involved in this case, who has never stopped talking about it. Well, maybe he has in the last 6 months or so, but I mean, it's a very fascinating case. Again, expression of fact versus opinion. Oberlin College students and Oberlin College Student Senate disseminated statements accusing a local bakery of having a history of racial profiling and discriminatory treatment of students and residents. And Oberlin College did take, the student body did take a very aggressive stance. They also boycotted the place, and they did their best really to drive them out of business. The statements accusing another of bigotry. So the Oberlin College Student Senate then passed a resolution that was disseminated for consumption by persons on campus, and Oberlin College students and a college administrator disseminated the flyer accusing this local business of having a history of racial profiling and discriminatory treatment of college students and residents, particularly those of color. The holding was that the jury verdict in state law cap on damages was upheld. The verdict was upheld. It was a very substantial verdict, and I believe a punitive damage verdict as well. Liability was incurred under Ohio law when someone aids and abets the publication of defamatory material. So there was an aiding and abetting component to this as well. So here we went beyond somebody having an opinion that somebody was a bigot, but the evidence showed, or at least the fact finders believe that the evidence showed that there was a specific desire to punish this business and put them out of business. So this does also get back into that discussion we started with, where when does speech cross the line from speech to action? Now, they don't directly address that in this case or any of these cases, but I mean, it's there sub silentio. In comic strip promotions versus in Vimeo, this is a New York State case, New York State Supreme Court. A comedy club made postings on social media platform likening the COVID vaccine mandate imposed by the city of New York for the treatment of Jews during the Holocaust, which I'm sure many of you heard similar kinds of certain kinds of treatment. Oh, this is just like what the Nazis did in World War II, and that kind of thing. Thereafter, a member of the New York City Council reposted the comedy club's posting and wrote a letter condoning anti-Semitism and condemning, I think it's supposed to be condemning anti-Semitism, and asking for public apology from the plaintiff. I'm sorry for that proofreading error. The holding was, the facts are the only phenomena that are capable of being proven false, and therefore the only phenomena that's actionable in a defamation case. In other words, defamation is about speech, right? So it's hard to say that, it is or is not speech in a defamation case. In order to prevail in a defamation case, a plaintiff must prove, as we know before in New York and many other states, special damages, unless the claim meets one of the exceptions under New York law. The claim against New York City Council member Julie Menon was dismissed, but the claims against the others were allowed to move forward per the court's order. So this was a case where, whether you want to call this speech that had become action, or whether you want to call this speech that was specific enough to be defamatory, or whether it was subjectively noble or malicious, all those doctrines have to be considered in a case like this, and they're all worth considering. Wiener versus Time and Life, another kind of odd and quirkish fact pattern. Plaintiff was an Orthodox Jewish rabbi and business owner. Now, he said that he was liable by a publication which had nationwide reach because they quoted him as saying that he does not wear a yarmulke, a head covering, as a religious Jew is supposed to, when driving in public, and he looked around more carefully due to incidents of anti-Semitism that occurred in the Washington Heights neighborhood near Yeshiva University. That basically he was being called a hypocrite. Again, expressions of fact versus opinion. Plaintiff alleged that the magazine portrayed him in a false light by claiming he would violate Jewish law by not wearing his kippah, his yarmulke. Now, false light was something I wanted to touch upon. In some of the cases that I have reviewed or handled, false light doctrine seems to have more life to it than defamation. Sometimes when you can't prove defamation, you might want to look at your state law on false light. And I've seen those cases. And I think the reason for that is there's a whole body of law on defamation and the First Amendment, which is somewhat skeptical of those cases, especially when dealing with what might be thought of as opinions or public figures. False light is more of a tort concept and seems to be more acceptable to courts in general. So that's a generalization, that's a big generalization. But again, if you're looking at one of these cases or you're thinking about it, don't forget to look at the false light doctrine in your state. Anyway, the holding in this case was the plaintiff had to prove special damages on New York law to have a triable case of defamation, and defendant's motion to dismiss was granted. So the guy took the easy way out and said, look, you don't have any special damages here, which it probably were not, other than hurt feelings. There are state criminal laws against defamation. Now, this was something I had an opportunity to look at in connection with a textbook being published by a law professor, and he wanted my view about that. Are there state criminal laws against defamation? Something I never had given much consideration to. But I represented a college professor at NYU, and this is really a bizarre story, where he was a very well-known Dead Sea Scrolls scholar, and a rival of his was also a well-known Dead Sea Scrolls scholar. The rival's son said that my client admitted plagiarizing. Well, my client never did plagiarize, and never admitted plagiarizing. So the state wound up bringing criminal prosecutions against the son of the rival professor. And the question here was whether this was a First Amendment, was it protected by the First Amendment or was it not? And it went on appeal because the man was convicted of 2 counts. And the court said, well, when it comes to the defamation claim, we're not going to let that go forward, First Amendment. But plagiarism, that's illegal. That's something different. And impersonation is something different. So the impersonation claim was, or conviction was upheld. State criminal laws against defamation or state criminal laws against defamation, which are usually in the nature of business torts and that are criminalized, such as the Florida statute imposing punishment for making derogatory statements concerning banks and building and loan associations. And don't say, oh, well, that's Florida, so it's different. Maybe it is different. But there are other state laws, all kidding aside, there are state laws around the country that criminalize what we would probably call business torts, particularly those which can be destructive of a business. Okay, restatement, third, defamation. So I thought we would sort of maybe not finish with this, but as we're coming to conclusion, take a look at the restatement, third, defamation. I'm a life member of the American Law Institute, and I've been through many of their discussions and debates over the years on the restatement third. The restatement third has, since its inception, it started out with products liability and gone through many, many different areas, contracts, and you name it. There's now a restatement third on a lot of areas. Interestingly enough, it's rarely quoted by the courts. It doesn't seem to have the stamp of approval that Prosser gave to the tort restatement second. But yet they're churning them out, and it gives a lot of work to a lot of brilliant professors around the country. I certainly enjoy the meetings when I can make them, but it's not been widely adopted. That doesn't mean it won't be in the future. Sometimes things like the restatement are, it takes some time for them to sink in. In the Virgin Islands, which is part of the Third Circuit, there's actually a statute that the restatement is the law they look to, is a specific, like a statute. And in many other countries, that's true also. I've had an opportunity to lecture in some other countries, and they treat the restatement as a much more holy document than we do. I mean, we look to it, obviously, all the time. Those of us that are involved in research writing, we always kind of say, well, what does a restatement have to say about this? But it's given very high a level of approval in other cultures, in other states, in other countries that look to American law. Many other countries do, because of the pervasiveness of American business. So the restatement third on defamation, I think Section 8 is pretty plain vanilla. Materially false statement of fact. To establish a defamation claim, a plaintiff must prove that A, a reasonable person would understand a defendant's communication to assert or imply a statement of fact, and B, the statement of fact is false, and C, the falsity of the statement of fact is material to the defamatory meaning of the communication. I think that's all pretty garden variety. Defamation by implication. Now, this is something you will not find in every state law, although the restatement is supposed to be a restatement of the law, right? But not always. Section 9, a defendant's communication that does not explicitly assert a statement of fact may nevertheless imply a statement of fact. If a recipient of the communication would reasonably conclude, based on the language and context of the defendant's communication, that the defendant intended to assert the implied statement of fact. So you can kind of like really snidely defame somebody, trying to be cute about it. And they cite for this proposed section lots and lots of state law that does find there is such a thing as an implied, if you will, implied defamation. But now this is what I wanted to talk about. I wanted to cover that background because we've been talking about the concept of groups, everything from cross burnings to protests outside synagogues, all that kind of thing. So what about defamation of and concerning group or class? Now, this really led to a very interesting debate on the Congress, on the floor of the American Law Institute, because there are those who see this as a First Amendment problem to punish this sort of defamation, and others who feel that groups need this sort of protection. So Section 11, defamation of and concerning members of a group or class. A defamatory communication that refers to a group of persons is of and concerning, quote, of and concerning, close quote, an individual member of the group if a recipient of the communication would reasonably interpret the communication and referring specifically to that individual member of the group. And now we're talking about not group defamation, but we're talking about an individual who has a claim because the nature of the defamation is to cast aspersion on a group that person is a part of. So we'll get into some examples about that in a moment. Factors affecting defamatory communication about a group. Factors affecting a defamatory communication about a group is of and concerning an individual within the group. Again, gotta find an individual who they're really talking about. Get down to the real motive here, Whether defamatory communication about a group is of and concerning an individual member of the group depends on factors such as group size. I'm not quite sure why size should matter, but it does here. The inclusivity or exclusivity of the language used by the defendant, whether they say all people in this group are bad or whether they say some people, well, particularly, tall, blonde men. There's only one tall blonde man, right? And the surrounding context of the defamatory statement. Surrounding context of the defamatory statement, which is pretty general, isn't it? Large group size. So group size, large group size does matter here, according to the American Law Institute. Group size is an important factor in determining whether a statement about a group is of and concerning any specific member. So the larger the group, the harder it is to say, that the speaker really means to defame a specific individual, which makes sense, right? As a general rule, defamatory communication about a large group is not of and concerning any specific individual within that group, particularly when the communication is couched in general terms. Well, is it couched in general terms? How do you talk about a specific individual, regardless of how large the group is? And this came up in the discussion of all is what most people are concerned about is political. You've got a political party and you like hate one person in the group, or the speaker defames the head of that party. And we see it, of course, all the time. Probably both candidates for president theoretically have all kinds of cases for defamation, right? Which they'll never bring. But if you're going to talk about all Republicans or all Democrats, it's going to be difficult for anyone, for example, to bring a claim on this, and whatever the group is. It could be religion, it could be political party. When defamatory communication is about a large group, reputational harm caused by the communication are likely to be diffuse and diluted. In other words, if you say bad things about enough people, well, that's better than saying really bad things about a small group where individuals are more identifiable. Anyway, that's the theory and thinking of the American Law Institute. And I think that's more for practical reasons than any legal reason. Large group size, allowing individuals to bring suit in such cases would produce a multiplicity of actions. So it's not practical, is really what they said. With potential damage is disproportionate to individual harms. In other words, too much money because there's so many people. Although there are some groups whose members are too numerous to be defamed, that number is not firmly fixed. So we don't know when a group is too large for an individual to be singled out. Nevertheless, the assertion that all dentists cheat on their taxes. I don't know, some of my best friends are dentists, sort of took objection to that. The assertion that all dentists cheat on their taxes does not suffice to satisfy the of and concerning element as to any individual dentist. And that would be true, right, regardless of the size of the group. Nor does the assertion that all of the lawyers in the 350-member firm of Rieders and Rieders, you all read your Dickens, that case, right? Bleak House, Rieders and Rieders. To say that all lawyers in the 350-member firm of Rieders and Rieders are liars, satisfying the other concerning element with regard to any particular lawyer in the firm. Again, the American Law Institute thinks would not be an appropriate body in which you can identify one individual as having been adversely affected. But what about the partners? What about Rieders and Rieders? And let's go a little bit further, not just liars, but they committed fraud. Suppose you said everybody in his firm commits fraud. There was a famous case in New York involving a law firm, which essentially was disbanded because they had a policy of doing fraudulent things. Like they had rulers that were 12-inch rulers, but it said 15 inches on it. So when they measured potholes, the potholes seemed larger than it really was. The whole firm was disbanded. I was actually involved in the coverage case because there were individuals who were not getting malpractice coverage because the malpractice carrier for this law firm in New York disavowed coverage, saying, well, this is fraud. We don't cover fraud. So I think, again, it depends on the details. And that's essentially what the American Law Institute was saying. I will talk a little bit, we only have a couple of minutes left, but I'm going to talk to you about a specific case, Podell versus Austin, which is my most recent civil rights case, in which wound up being transferred from the Eastern District of Pennsylvania to Virginia. And this was a case study that came on the heel of Grouse versus DeJoy. So Grouse versus DeJoy was a U.S. Supreme Court case recently decided where the United States Supreme Court sent back to the Third Circuit a case involving a man who refused to work for the Postal Service on Sunday. He was a Sunday Sabbath observer. And he was in a small post office in Lancaster, Pennsylvania, with I think it was 2 or 3 other people. And although there were attempts made to offer him a reasonable accommodation, none could be made. And he wound up quitting and suing. And the court basically said that the de minimis test that hitherto had been utilized to determine the efforts that an employer had to make was really obiter dicta. And the court created a new test saying, you've got to really look at all of the elements and costs and all of the issues involved when you determine that you have made a good faith attempt to afford a reasonable accommodation and could not. Podell versus Austin followed on the heels of that. In fact, Podell was advocating curiae in DeGraff. But Podell's case was a much stronger case in that Mr. Podell was a member of the Jewish faith who would not work on a Saturday, applied for a job with the Department of Defense, and although he went through all the steps of trying to obtain a reasonable accommodation, none was afforded to him, even though there were potentially thousands of people who could cover the testing so that he wouldn't have to do it on a Saturday, he could do it another day of the week. And perhaps the most interesting thing about the case was the reaction of the court. The judge was Judge Ellis, appointed by Ronald Reagan. You would expect, I would have expected to be fairly conservative. He was outraged when the United States of America, and this is we're talking about the fall of 23 into January of 24, took the position that a member of the Jewish faith asserting that he was entitled to reasonable accommodation needed to prove that a Sabbath observance was legitimately part of the Jewish faith, and needed to show it through statistical evidence. And there are cases, by the way, where a policy of an employer is sufficiently unclear as to its intent, so that statistical proof is afforded. For example, whether it's a certain kind of weightlifting regulations, or whether they discriminate inherently against women. But failing to afford a reasonable accommodation to someone based on their religion, where the employer says that they do afford reasonable accommodations, but refuses to even investigate it, as in the case of Mr. Podell, this court, the federal court, felt was an outrageous defense of the case. So it ultimately resolved with the Department of Defense agreeing to change its policies, the way it evaluates people, the testing procedures, etc., so that the likelihood of failure to afford a reasonable accommodation is less than it was previously. So these are all interesting cases. I think our hour is up. I hope that you got some thoughts about it, some guidance about it as you work in these fields of defamation, the First Amendment field, that you work long and hard to, because they're not easy issues. So I wish you success and good luck and good health. Take care.